This is happening around the country. This is Proposition 2 in Michigan from 2022. But similar propositions have passed in other states, but we're going to focus on this one in Michigan because it's instructive. It's illustrative. Tell us what Prop 2 is and what you're challenging.
Sure. There are actually two ballot initiatives in Michigan, one in 2018 and one in 2022. And that's where all these changes to the election laws came in. And we have ballot stuffing now, and we have people having multiple ballots come to their home, and the extended voting and all those things that have been passed by ballot initiative in the last couple of years. And so we believe that violates Article 1, Section 4 of the federal Constitution, which says very clearly that the time, places, and manner of holding elections for senators and representatives, now we're talking at the federal level, so holding elections for Congress, shall be prescribed in each state by the legislature. Now, that seems pretty clear. That's what the federal Constitution says. And so
it is, but if I may be so bold, hold on, before we go too far here. The state of Alabama was just told by the United States Supreme Court, as was the state of North Carolina, that the way they drew their congressional districts was not going to pass muster. Even though they presented the same argument you just presented. They said, no, you can't do it that way. So it's not an ultimate state legislature gets to do this because they just said no at a conservative Supreme Court. But go ahead and tell us about what you're doing and why it would be different.
Yeah, why it's different in this case, Steve, is that's a different clause of the federal Constitution that they argued that under. It's a similar principle, but it's a different clause. And what we have in our case dealing with time, place, and manner of federal elections for congressmen and women is we have prior case law, whereas a very close vote a number of years ago, 5-4, that upheld a state doing it this way with a ballot initiative. But 4 justices, including Justice Roberts, who wrote a scathing dissent, really quite vociferously dissented in that decision. And now we've had a shift in 2 different justices now on the court. And you only need 4 justices to take the case up and to revisit the issue. And we believe that we have a court now with a majority that will rule our way on it. Now, it's up to the justices, obviously. But Justice Roberts made it real clear that he believed when the federal Constitution said legislature, it meant legislature.
So what happens then? What's the process here? And what's the real issue here? All of these, they're trying to bake in all the games they played during the pandemic. That's really what's happening here. That's what the left wants: mass mail-in ballots. They want people to be able to harvest ballots. They want people to be able to, go to their friend's house, help them fill out the ballot, and turn it in for them. There's nothing about that that's secure at all. But what's the process from here?
Well, the process is we filed a federal lawsuit in federal court here in Michigan in the Western District. It has now been served. The Attorney General acknowledged service. The state, we've sued Jocelyn Benson, the Secretary of State, for declaratory ruling on this issue and for an injunction to stop these 2 ballot proposals from continuing to be implemented. And so they now have till the first of the year, early January, to file an answer and a response. I'm sure they're going to file a motion to try to dismiss based on the earlier case we were just talking about. And then it's going to go up. It's a legal issue, and we're going to take it all the way to the U.S. Supreme Court, and that's going to be the process. We'll see what happens at the district court level. Then we'll take it to the 6th Circuit, and then if need be, we'll go to the U.S. Supreme Court.